It's August 8th, 2023, and this is the first ever episode of Exposing Dirtbag Attorneys. We have 3 in our sights from California today, but first up, I have some disclaimers. Number 1, I have a lot of liability insurance. Number 2, I believe everything in this video to be true. Number 3, we have cameras in our courtrooms here in Nevada. Number 4, we have active groups who will court watch and also record proceedings in Nevada courts. Any corrupt attorneys who have gotten the idea that they may use the courts as a weapon, you have been warned. Also, there's a newly passed rule in California. It's Rule 8.3. Any California attorneys who see this video and see credible evidence of attorney misconduct or crimes committed by attorneys have a duty to report what they have seen to the California Bar. Some backstory for those of you who are new to the channel. On July 7th, 2019, my children were abducted from Nevada by their mother and withheld in the state of California. She and her attorney have used the San Jose Family Court to withhold my children in California for 4 years now, without due process, using a combination of professional and judicial misconduct, as well as fraud upon the court, perjury, and law enforcement's refusal to investigate. The Bar Association of California, of course, has also refused to investigate. However, I'm happy to report that one of the attorneys featured in this video is now under current investigation. And this would be that attorney right here. His name is Tristan Aeschleman, and his bar number is 278981. On July 24th, 2019, I filed my first bar complaint against him. I'm going to go ahead and read it to you quickly because not everybody watches these videos. They listen to them. For those of you who want to skip ahead, feel free. I'm not going to read every document in its entirety, but in this one I will. I have had primary custody of my 2 minor children in Las Vegas since August 4th, 2018. Their mother, Shelley, ceded primary custody to me in writing due to her arrest for DUI with the children in the car in South Lake Tahoe, California. Nevada is their home state. They have completed the entire 2018-2019 school year in Las Vegas at Mathis Elementary. There are no permanent custody orders out of any court in the United States of America. There was a case filed in Santa Clara County Superior Court in 2012. Temporary orders were issued. However, Shelley and I mutually agreed to dismiss the case subsequent to those orders, and we executed a request for dismissal through our attorneys in October 2012. We have been operating by private agreement ever since. Shelley and I entered into a private written agreement on May 7, 2019, in which she would be allowed to remove the children from Nevada on May 23, 2019, and would return the children to Las Vegas on July 7, 2019. On July 7, 2019, she did not return the children. Instead, I received an email from California attorney Tristan Aeschleman. In it, he explicitly acknowledges my above reference agreements with Shelley and states that she has changed her mind and wants to amend our agreement about the boys living in Las Vegas permanently. He states she wants them to return to South Lake Tahoe for school. Instead of properly advising his client to return my children immediately to their home state as agreed, he instead advised her to withhold and conceal my children in violation of Penal Code 278.5, and he attempted to blackmail me by stating that I would not get my agreed upon summertime custody unless I bowed to their demand and the children moved back to South Lake Tahoe. He further threatens that he filed a motion in the case that should have been dismissed. I have not been served with anything. On July 8, 2019, I called the clerk of Santa Clara County Superior Court and discovered that the previous case had not been dismissed. I would like to file a complaint against the attorney that failed to file the executed request for dismissal in 2012. However, he is no longer active in the bar. His name was Peter Boscovich, bar number 87948. When you go through this process in 2019 of filing a complaint, the system does not tell you until the very end that there are these extremely limited file size limitations, like extremely small. Like you can attach 10 files that are 3 megabytes each. So for a number of reasons, that would be one of them. I only attached this one thing, which was the email from Tristan Ishelman blackmailing me. This, of course, I was surprised because the day that they were supposed to be due back in Las Vegas, which was July 7, 2019, They were not returned, and instead I got this email from him. So there was a flurry of activity, including me filing a civil case here in Las Vegas, me attempting to go to both the Las Vegas police and the South Lake Tahoe police, both of whom refused to do an investigation, refused to let me make a report, which, by the way, is a felony in both states. Impeding the victim of a crime from reporting a crime is a felony in Nevada and in California. There have yet to be any consequences for the officers and employees involved in that issue. So I attached one email to this complaint. That was the email from Tristan. Here it is right here. It says, Mr. Sternberg, my name is Tristan Aeschleman. I'm an attorney in San Jose, California. Recently, Ms. Warneck retained our office to address some custody and visitation issues involving Evan and Nathan. Now, what I later found out, and this is just for your situational awareness, is what he means by recently retained was actually several months prior. Shelley admitted in a deposition in June of 2020 that she had actually retained him in March of 2019. So while the boys were in school here in Las Vegas, she retained him in March of 2019 and planned what she was going to do for March, April, May, June, July. He was retained that entire time. Now, that entire time, he did not substitute into the case that I thought was dead in San Jose. The reason why he did not substitute into that case, of course, is because he would have to serve me that substitution, and then I would be alerted that the case was still open. So he did not serve me with the case, with the substitution, because he did not substitute in. And because he did not substitute in, he did not get the court file. This is a confidential case. They would not give him the court file unless he was representing a party. Furthermore, I am 100% sure he didn't get the court file because when I later went to try to go get it, it was still in storage from 2012. So Tristan Aeschleman did no due diligence to figure out if he was about to participate in any crimes. The email goes on to say, I understand that you asked Ms. Warneck to bring the boys back to Las Vegas by July 7, 2019, and that you intend on having them attend school in Las Vegas again and next year. That was an explicit agreement. He knew that that was an explicit agreement. Ms. Warneck has admitted that that was an explicit agreement, not only in Las Vegas court, but in the actual declarations and motions that they filed 2 days after sending me this email. So he knew that that was an explicit agreement. While Ms. Warneck agreed to the boys attending school in Las Vegas last year due to the then circumstances, she has not been and is not in agreement with Nathan and Evan primarily residing in Las Vegas on an ongoing basis. Ms. Warneck would like them to remain with her in California, which is consistent with the long-term status quo. The current orders provided that Ms. Warneck has primary physical custody of the boys. Okay. Again, this case should have been dismissed. These so-called current orders are temporary orders that were attached to a fraudulent stipulated judgment that I never stipulated to. So these are temporary orders that were fraudulently entered with the court as if I had agreed to them, which I did not agree to them, and nor did I agree to the stipulated judgment. So what apparently happened was the stipulated judgment got filed instead of the dismissal. All the stipulated judgment says is that we have joint legal, joint physical custody. So not only by statute do we have joint legal, joint physical custody at this time, but also by this fraudulent stipulated judgment. So mother had no presumptive right to relocate these children from Nevada without my permission. Law enforcement and the courts, of course, are trying to pretend like she does or did. The email goes on. There is also an order prohibiting you from removing the boys from South Bay, California. Well, the boys hadn't lived there in years. I hadn't lived there in years. And mother, again, agreed to relocate the children to Las Vegas. So how you're going to enforce this temporary order that is alleged I agreed to, that I never agreed to, is beyond me. It is my understanding that while there are temporary visitation orders, Ms. Warneck and you have been able to reach alternative arrangements over the past several years to accommodate in part your relocation to Las Vegas, Nevada. Ms. Warnick would like to have a more defined plan in place that provides for the boys primarily residing in South Lake Tahoe and have time with you there and in Las Vegas. With that said, based on your prior statements to her, we are aware that you are not in agreement with that. As such, she has filed a motion with the family court in Santa Clara County to address this issue. To this day, that motion has never been served on me. It's been 4 years. That motion was never served on me. But as I have already told you, in that motion, she admitted that she had agreed to permanently relocate these children to Las Vegas, Nevada. She had admitted that we had an agreement regarding the summertime visitation for the summer of 2019. So she had just basically took it upon herself to withhold these kids, then file a motion in a court in a jurisdiction where nobody lived, hide the kids from me, never serve the motion, and then have her attorney send me this email. His email goes on to say, Ms. Warnick does not want to impede your time with the boys this summer. However, unfortunately, she is concerned that if the boys are brought to Las Vegas, you will not agree to return them to South Lake Tahoe for the school year, irrespective of the current orders. So here we go again. He has no idea what the current orders actually are because he never went and got the court file. So he doesn't really know what the latest and most current orders are. As a result, she does not intend on bringing them back today or until this matter can be addressed with the court or unless you two are able to reach a written agreement. We already had a written agreement, and again, she already admitted that in a declaration she filed a couple of days after this email. Again, she does not want you to keep the boys from you, so I would like to discuss options to address this issue. Also, so you are aware, Ms. Warnick intended on giving you notice of this before today. Due to some logistical issues and the holidays, this was not able to occur. Finally, it's unclear whether you are still represented by an attorney. If you are, please let me know. Again, I would like to discuss options with you so we can address the remainder of the summer. So, in response to this, I immediately filed a case in Nevada. Many of you have seen those hearing videos because we do have cameras in our courtroom, thank goodness, in Nevada. For those of you that haven't, check out the playlists. There are 2 hearing videos so you can see the other things that she admits to. This is the closeout letter I got from Scott Carp. So just as a reminder, this complaint was filed on July 24th, 2019. By August 14th, 2019, he had closed it out. He never once contacted me, never did an investigation. In fact, admits in this letter to not having done an investigation. So let's go through it together. See if we can't spot absurdities and misconduct. We are closing the complaint. In order to investigate allegations of attorney misconduct, the state bar needs specific facts which, if proved, would establish a violation of the attorney's ethical duties. Okay. Let's go back to the original complaint. I have had primary custody since here. The mother ceded custody to me. There are no permanent custody orders in any country, any court in the USA. We have been operating by private agreement ever since. This is a sworn document, so I'm asserting facts. We entered into this private agreement. The children were not returned, and instead I received this email from Tristan where he explicitly acknowledges the above referenced agreements with Shelley and states that she has changed her mind and wants to amend the agreement. Okay. Again, she had no presumptive right to relocate these children. Furthermore, relocating the children without prior approval of the court is a felony in both states. It's NRS 200.359 in Nevada. It's California Penal Code 278.5 in California. The one in both of them say getting a court order after the fact is no defense. Also, under civil law, temporary moveaways are illegal on due process grounds. I also allege the fact he attempted to blackmail me by stating that I would not get my agreed upon summertime custody unless I bowed to their demand and the children moved back to South Lake Tahoe. These are all facts alleged that, if proven true, not only would be misconduct, as we'll go through later, but would be actual crimes and actually felonies in both states and a felony under federal law. Under federal law, I have a fundamental right under the Constitution to the care, custody, and control of my children. Conspiracy against rights is a federal crime. Scott Carp goes on to argue conclusions based on speculation and not supported by facts are insufficient to warrant an investigation. Excuse me, I alleged specific facts, which, if proven true, would be misconduct. The way that you prove them true or false is by doing an investigation, which, as we will talk about later on, is mandated by the bar rules that an investigation be done. It talks about what an investigation is, it defines it, and says that it shall be done. It's kind of ridiculous to say that I'm speculating when Tristan Aeschleman is admitting that he is aware of our agreements and that he is representing the mother and that they are not returning my kids. That is not speculation as to what he's doing. I'm not speculating as to what he advised her to do. She clearly is withholding the kids under the guise that she has some kind of legal authority to do that. And some of you are going to bring up this whole thing about lawyer-client confidentiality. There's a crime fraud exception. You cannot hire a lawyer to commit a crime. If you hire a lawyer to commit a crime, you do not have confidentiality. Scott Carp acknowledges that I attached the email. He says there are no facts in the email which support your conclusion that Mr. Aeschleman failed to advise or improperly advise his clients with regard to the custody issues, which of course we just discussed is ridiculous. Mr. Aeschleman's failure to serve you with a motion, if true, would not be misconduct, and there are court remedy with regards to improper service. Okay, let's review the rules of professional conduct. Here's one rule that applies. There are others that apply, but let's just choose one. Rule 3.2, delay of litigation. In representing a client, a lawyer shall not use means that have no substantial purpose other than to delay or prolong the proceeding or to cause needless expense. So this idea that failure to serve is not misconduct is a joke. It's especially a joke in the context of a kidnapping. And this whole idea of me taking it up with the court is this game that these lawyers like to play. So you file a complaint with the bar, they say, take it up with the court. You go to the police, they refuse to investigate or do their jobs, and they say, upon advice from our general counsel, we are not getting involved in this, take it up with the court. You then take it to the court where a lawyer who is also a judge denies you due process and then says, if you have a problem with misconduct, take it up with the bar. So you just go around and round in circles, and none of these people who all are licensed attorneys will do their job. Continuing on with the Scott Carp closeout letter, it says, if there's a case still open, you may want to address your custody issues there. The state bar is not a trier of fact and cannot make a determination as to facts and merits of this matter. The state bar is not a trier of fact, okay, but it's an investigative body that should be investigating whether this stuff is true and whether there's probable cause to pursue misconduct proceedings against this attorney. The fact that Scott Carp would put this stuff in writing is just emblematic of how far gone and corrupt the California Bar Association really is. I'm not going to read the rest of this, but it says, if you have new facts and circumstances that you believe may change our determination to your complaint, you may submit a written statement for review. Why would I go back? Why would any right-thinking person or correct-thinking person go back to somebody that is this blatantly corrupt and biased? Why would anybody do that? You wouldn't. And then in terms of escalating up through the appellate process, because there's an appeals process, that whole process is defunct and broken, and we'll be addressing that in later videos. I have brought it up with the Board of Trustees, and for those of you who've been watching my public comment videos, you can see that there. Okay, so this was all in 2019. Well, then I had to deal with the police refusing to do their jobs, the family court denying me due process on a regular basis, my own attorneys defrauding me, so I didn't get back around to this until later. Okay, now we're going to fast forward to 2022 and 2023. Many of you who are subscribers and regular watchers of this channel know that in August of 2022, I started attending the California Bar Association Board of Trustee public meetings and making public comments, making my voice heard, reporting crimes and misconduct straight to the board. A year later, we've made very little progress, but like I said, at least we can say that one of the attorneys, namely Tristan Aeschleman, featured in this video is finally under current investigation. And again, keep in mind that I'm battling literally everyone in this ordeal. So all of Nevada law enforcement refusing to do their jobs, all of California law enforcement refusing to do their jobs. Not only that, they came after me and arrested me and then maliciously prosecuted me. So that silenced me for a while I was dealing with that. But in May of 2023, I took up this complaint process again. And this time I started writing letters straight to the California Board of Trustees regarding Scott Carp and his initial refusal in 2019 to investigate Tristan Aeschleman. So first I wrote a letter. The letter is dated May 1st, 2023, and it reads, Executive Director and Board of Trustees. In the summer of 2019, my children were abducted from Nevada by their mother. So here again, I am reporting a felony. In Nevada and in California, it is a felony to relocate children without prior permission of a court and without the permission of the other parent. In the summer of 2019, my children were abducted from Nevada by their mother and withheld in California. As cover for the abduction, she and her attorney resurrected an old family law case in San Jose, California, where neither the parties nor the children lived. On July 24th, 2019, I filed a bar complaint against her attorney, Tristan Ishelman, because his very first communication to me in email was explicit blackmail and on its face demonstrated that he had knowledge, which made his conduct professional misconduct. In my complaint, I alleged several acts of misconduct and that Tristan was knowingly participating in felonies. I am enclosing my original complaint. Rather than investigate or make contact with me to discover if I had more evidence to produce, Deputy Trial Counsel of the California Bar, Scott Carp, closed my complaint in a letter on August 14, 2019. Instead of putting in a modicum of effort to explain the process to me as required per Business and Professions Code, subsection 6092.5G, Scott Carp elected instead to put into writing such absurdities as, in addition, Mr. Aeschleman's failure to serve you with a motion, if true, would not be misconduct, and there are court remedies with regards to improper service. Rule 3.2 says otherwise. So here I am citing their own rules for them. Perhaps under normal circumstances it might not be misconduct, but not when Tristan Aeschleman explicitly acknowledged participating in a kidnapping, but claimed, quote, as such, she has filed a motion with the family court in Santa Clara County to address the issue. See paragraph 4 of his email dated 7/7/2019. Because my children had been abducted, a lot of activity occurred very quickly, including me filing police reports in a civil case in Las Vegas. There was a flurry of email traffic between attorneys, which demonstrated misconduct on the part of Tristan Aeschleman. His misconduct continued and got worse, and as a result, my children remained abducted 4 years later. I've never had a trial and cannot get basic due process. None of this would have occurred had Scott Carp set up a basic investigation and allowed me to supply evidence as it came in. I request that you investigate this issue and remove Scott Carp from having anything to do with misconduct complaint process and take further action as the board deems appropriate. I will be refiling my complaint against Tristan Ishelman today. I have a plethora of evidence to send in documenting misconduct. I am requesting that the same investigator be assigned to all of my complaints so that a coherent timeline can be built with supporting evidence. I further request that once the California Bar determines that based on evidence I have submitted, crimes have occurred, may have occurred, that you refer the matter to the San Jose, California Police, the California Attorney General, and to the FBI for further investigation. And sincerely me. And then I included those letters. Okay, so I sent that. Then I filed the complaint against Scott Carpf using the bar's online complaint system. So this was also May 1st, 2023. I filed the complaint. Scott's bar number is 274682. And here's the body of the complaint. I said, it says, what's your connection with the attorney? I said he was the deputy trial counsel in bar complaint. That was my initial complaint against Tristan Aeschleman. So the body of my complaint says, on July 24th, 2019, I filed a bar complaint against Tristan Aeschleman. I gave the case number, in which I alleged numerous acts of misconduct and actual crimes. Because of file size limitations, I attached one email to the complaint, the initial communication to me from Tristan Ishelman, in which he clearly blackmails me and demonstrates knowledge of facts which would make the email itself, on its face, misconduct. Rather than do any kind of basic inquiry whatsoever or meet his obligations under Business and Professions Code 6092.5G, Scott Carp closed my complaint on August 14th, 2019, without giving me a chance to explain the scope of the complaint or to supply evidence. The result is that 4 years later, my children remain abducted because of due process violations in the court, further misconduct by Tristan Ishelman, and misconduct by my own attorneys. This never would have occurred had Scott Carp started a basic investigation instead of blowing me off. I will be refiling the complaint against Tristan Aeschleman. I have a plethora of evidence to submit, and I'm asking that the same investigator be assigned to all of my complaints. Just to clarify, the reason I'm asking for the same investigator is because it's one timeline of facts, one timeline of evidence to document misconduct by a lot of attorneys. As you can see here, I attached the letter to the board as evidence for this complaint. Okay, so since I complained about an attorney that works for the bar itself, the chief trial counsel or the general counsel of the bar is disqualified under the rules, which makes sense. They should not be allowed to investigate themselves. So it goes out to something called the Special Deputy Trial Counsel and the Special Deputy Trial Counsel Administrator. They're the ones who are supposed to investigate complaints involving attorneys who are bar employees. So on May 11th, this guy named Lawrence J. Dal Cerro, Special Deputy Trial Counsel. So 10 days after I filed my complaint, he closed it. And he closed it by writing this extremely long letter. At no time did he contact me and do an investigation. So a lot of this letter is just, again, them never addressing the fact that they refuse to take evidence, that they refuse to investigate, and instead it's a bunch of gobbledygook and conjecture, which has already been refuted by my complaints. And it's also refuted by the law and the rules themselves. And these people don't even realize what they're putting into writing, apparently. So first things first, let's show Dal Cerro's bar number. So this is the guy. His bar number is 104342. This guy's been a lawyer since 1982, which is kind of frightening. Just goes to show you again how far gone this profession really is. So reading this entire letter, I think, would bore you to death. So what I'm going to try to do is pick out some key points. And so first of all, like I said, he never investigated. And in fact, I'm going to show you after this how I responded to this letter to the Board of Trustees. And I will single in on the fact that he didn't do an investigation as required of him. So he makes a rule citation here and says that he's obligated to close the complaint. Kudos to him for at least citing a rule, because most of the time, these government losers, they never cite rules. And when you cite rules, they just ignore you. So kudos to Lawrence for at least citing a rule, but the rule doesn't say what it says what he purports it does. There is no obligation to dismiss a complaint. There is an obligation to investigate a complaint. The rule actually says you shall investigate. He does admit to reviewing my complaint carefully, including the letter which was directed to the Board of Trustees. He then goes on to talk about how he, reviewed a bunch of bar records, which is sad and amusing because, of course, I'm complaining about bar employees. A lot of those records were generated by the people I was complaining about. The other rule they invoke is this thing with discretion. I'll point this out again in a moment with the letter to the board. But the rule that he's invoking is an abomination. They're basically claiming that they have absolute discretion, including discretion to refuse to investigate misconduct and crimes by attorneys. Okay, so here's an interesting point. He goes, I appreciate that your complaint has a finer point. You have alleged that Mr. Karpf should have done more to gather evidence to develop the case before deciding what to do with it. In response, I note that he in fact tried to do so, albeit as a follow-up to his initial closing decision. So this is where he invites me to submit more evidence. Well, if you're saying that refusing to serve me is not misconduct, or failure to serve me is not misconduct, and if you're saying that participating in a kidnapping is not misconduct, why on earth would I go back to you? Why would I go back to you? You obviously have a screwed up mind. I am not going back to you. Again, citing records. I don't know what he looked at. Okay, so here again is this circular, chasing your tail. I asked them to report the criminal conduct. He declines to do so, invites me to go to law enforcement. Law enforcement refuses to follow their own rules, their own policies, the law, and then their general counsel attorney will usually write some kind of gobbledygook to provide cover for them. And they'll say, if you don't like what's going on, go to the court, meaning the family court. The court then denies me due process. And when I complain about the felonies and the professional misconduct, they're like, well, go to law enforcement or go to the bar. And you just chase your tail. You go round and round in circles. And that's why 4 years later, my children are still abducted. He again invites me to come back to him. Why would I do that when you didn't investigate in the first place? He also puts this arbitrary deadline in there of 10 days. That's not in the rules. He says I can request a review. If I want to do so, I must do it in writing within 90 days. Where's the 90-day time limit? That's not in the rules either. Okay, so that's the entire letter. You should have all had a chance to scroll through it if you really wanted to read it. Okay, we're in the final stretch for this video. I could have picked Dal Cerro's letter apart point by point, but it would have been a waste of time because, as I'm hoping you're gathering by now, these people don't read, and when they do read, their brains are broken. So instead of going point by point and addressing all the falsehoods that Dal Cerro puts forth, both in fact and in law, I focused on the bigger issue, which was the fact that he didn't do an investigation as required of him by the rules which govern the process. He didn't contact me. He didn't ask me for any extra evidence. He didn't ask me if the understanding of the facts that he had was correct. He didn't contact me. He spent 10 days playing games, allegedly looking at bar records, and then drew up a bunch of nonsense in a letter and closed it all out. So my response is to go after him with the Board of Trustees and using the rules, addressing the fact that he failed to follow those rules. So let's go over the letter I drafted up in response to to the Board of Trustees. I hope you guys like my new logo that I'm putting on the top of every single letter now that's going out to these people. I'm sending it to the administrator, Special Deputy Trial Counsel. That's the person, if you recall, in his letter, he said I had 90 days to request a review. So I'm requesting a review. I sent it certified mail, return receipt requested. I sent it to the board and the executive director of the bar through Louisa by email to she's the secretary. And I sent it also by mail to the chair and vice chair of the Assembly Judiciary Committee. For those that have been watching the channel, you know that the Assembly Judiciary Committee has been all over the bar about its malfeasance. And if you haven't seen those videos, they're very interesting. I invite you to go look at them. So I typed up this response. We're going to go over it quickly. It says, to all concerned, on May 1st, 2023, I filed a complaint of attorney misconduct with the State Bar of California against one of its own, namely Scott Carp, bar number 274682. That same day, I sent a letter to the Bar Board of Trustees and the Executive Director informing them of the complaint. On May 11, 2023, Special Deputy Trial Counsel Lawrence J. Dal Cerro, bar number 104342, sent me a letter closing the complaint. Pursuant to State Bar Rule 2201 D2, I am requesting review of the decision to close my complaint. Pursuant to State Bar Rule 2201 E1 and 5, I am requesting referral of this matter to the Regulation and Discipline Committee, and that Chair Rubin remove Dal Cerro from all Special Deputy Trial Counsel duties. I'm not going to show the rules here. You can easily Google them. Just Google California State Bar rules. You can see the PDF and go straight to those citations to see what I'm talking about. My reasons for the above requests are, number one, Dal Cerro has perpetuated the culture of corruption at the State Bar by failing to adhere to the letter and intent of the State Bar rules. Further, his letter demonstrates explicitly the level of bias the State Bar culture has against non-attorney complainants. Number two, State Bar Rule 2201D lays out the duties of the Special Deputy Trial Counsel. 2201D2, I believe that's a typo, it should say D1, states, upon receipt of a referral by the administrator, the Special Deputy Trial Counsel shall conduct an investigation and all such other proceedings as necessary and appropriate. Rule 5.442 defines investigation. Investigation means the process of obtaining, evaluating, and reviewing evidence and information. Rule 2401 states the purpose of an investigation is to determine whether there is reasonable cause to believe that an attorney of the State Bar has violated a provision of the State Bar Act or rules of professional conduct, and if there is sufficient evidence to support the allegations of misconduct. At no time has Dal Cerro contacted me as part of an investigation or to obtain evidence, which I find unreasonable given that my underlying complaint was about refusal to investigate. Further, at the time of his writing the closeout letter, Dal Cerro was in possession of my complaint against State Bar employee Melanie Dorian, bar number 197955, in which I went into greater detail about the State Bar's refusal at multiple levels to investigate my complaints against attorneys or to take evidence, and how the bar was in violation of California state law. I find it entirely unreasonable for Dal Cerro to have closed out my complaint without contacting me to ensure he had a correct understanding of the most basic facts of my underlying complaint, or to obtain evidence while instead relying on bar records, some of which were generated by the people I was complaining about. My concerns about Dal Cerro's letter. Number one, Dal Cerro has subverted powers delegated to the Special Deputy Trial Counsel Administrator. Specifically, in paragraph 2, he states, under the rules governing my review of your complaint, I am obligated to close your complaint if I conclude that your complaint would not result in Mr. Karp's discipline. Typo. See Rule 2201C3, Rules of Procedure of the State Bar. His citation demands no such obligation. It describes the duties of the Special Deputy Trial Counsel Administrator, which he is not, and reads, the administrator shall have all the powers and duties of the Chief Trial Counsel and shall act entirely in the Chief Trial Counsel's place with regard to an inquiry or complaint or other matter and any other resulting investigation or prosecution. So the next logical question is whether the Special Deputy Trial Counsel Administrator, acting in place of the Chief Trial Counsel, is obligated to close my complaint. For the reasons below, I argue that such a perspective is intolerable. Number 2, invocation of Rule 2601. Dal Cerro invokes a rule which reads in part, the Office of Chief Trial Counsel may, in its discretion, close an inquiry, complaint, or investigation. What are the limits of this awesome power? This rule is an abomination, and I urge the Board of Trustees to revoke it. There should be nothing whatsoever giving the State Bar a leg to stand on and knowingly turning a blind eye to misconduct and crimes committed by attorneys, which is what Dal Cerro clearly argues is allowed. Not only may he turn a blind eye and refuse to investigate, but that he's obligated to do so. Number 3. In the middle of page 3 of his letter, Dal Cerro states, again, this is the state of the record as it relates to your complaint at the time it was evaluated by Mr. Karpf. In evaluating your complaint, Mr. Karp would have followed State Bar practice governing the intake process. Among other things, this practice provides that in order for a matter to advance from the initial review stage to a full investigation, a complaint must allege colorable, i.e. actionable, violation and include a recitation of facts specific enough to establish the violation. He, of course, provides no citation for that. Here, Dal Cerro makes my case for me. He is referring to my original complaint against Tristan Aeschleman, to which Scott Carp was assigned. The complaint on its face alleged specific facts which, if proven true, would be misconduct and criminal. However, Scott Carp and now Dal Cerro are putting the entire burden of an investigation on me, the complainant. Their positions in their closeout letters are clearly that I, the complainant, must conduct the entire investigation myself, somehow issue subpoenas, somehow do depositions, and then put the entire thing together for the bar in an official report. This is absurd. Further, I remind the bar that at the time I filed the complaints against Tristan Ishelman, the bar website had extremely restrictive file size limitations, prohibiting me from including more evidence. Number 4. The rest of Dal Cerro's letters conjecture about my case, much of it already rebutted by my sworn complaints, i.e. articulated and alleged facts, filed with the bar, and I am therefore not going to address it in this letter. Note for the record that in separate bar complaints, I finally broke through the lawyer gatekeepers and got a non-lawyer investigator assigned. She, being reasonable, called me to make sure she had a good understanding of the allegations to ascertain what evidence I had in my possession, provided me a mechanism to supply it, and a discovery of the location of evidence not in my possession. That is exactly what should have been done in my complaint against Scott Carp and my initial complaint against Tristan Aeschleman. California Rules of Professional Conduct 8.3 Notice. To licensed California attorneys. This correspondence and its attachments documents evidence that a California lawyer or lawyers have committed a criminal act or acts and or engaged in conduct involving dishonesty, fraud, deceit, or reckless or intentional misrepresentations, and you are required to report it to the State Bar or an appropriate tribunal. And then here I put the conspiracy against rights. You can read that citation for yourself. That is just basically a copy of the law. Okay, so that's it for tonight. I hope you enjoyed the first ever episode of Exposing Dirtbag Attorneys. As you can see, they are masters at creating tons and tons of unnecessary work. At no step in this process has anybody from the bar done an investigation as it relates to these specific complaints. And had they done a basic investigation and allowed me to submit evidence, we would not be where we're at 4 years later. But they didn't do that. And they didn't do that because they're corrupt. And that's the way that it's been going both at the California bar, the California judiciary, California law enforcement, Nevada law enforcement, in my case and in many other cases for many, many, many years. The system is badly broken, needs reform, and needs accountability. And I'm going to use my First Amendment rights here on YouTube to expose it all. Boys, I miss you. I love you. I hope I see you soon. YouTube, if you don't know why I'm the father in exile, check the links in the description or the pinned comment.